Oh, good morning. I was asked a very interesting question regarding contracts, and I thought it would be helpful for us to discuss it. But may I put a disclaimer then? Whatever we're discussing today, it's not extensive legal advice. Should you require further advice, you are welcome to approach Clementina Tai Attorneys. You will find the details above. Let's just dive into it. The big question is, are you bound by a contract that you didn't sign? Or rather, are you bound by a contract even if you didn't sign it? That's the question today. And unfortunately, the answer is yes. Specifically in South Africa and under South African law, you will be bound by such a contract because a signature, it's not a universal legal requirement for a contract to be valid. There are some contracts that specifically require to be in writing, therefore have a signature in terms of legislation. We will touch on those. For now, let me just indicate that for as long as a contract has all the elements of validity, one being acceptance, being capacity, lawfulness, and possibility, you must know that that particular contract will be binding. Be it is a tacit contract, meaning it is according to your conduct. You have either accepted the goods, you have either accepted the service. You will be bound, even if it's not in writing, even if you don't have your signature on it. A contract may also be binding, even if it's just verbal. Let's talk about those WhatsApp notes that you be sending, promising people stuff. It is binding, and it is recognized so in our law. For example, some of the emails that you're sending, they can be binding even if it's not your signature in terms of the Electoral Act. Voice recordings where you are getting a call, for example, from an insurance company selling you something, those can be binding. Back to those contracts that I spoke about earlier, where I said in terms of legislation they are required to be in writing, therefore a signature will be there. One of it is the sale of immovable property. We will get onto it on another episode. The other one is a suretyship agreement, bank guarantees and whatnot. You will have to have your antenuptial agreement reduced to writing and therefore signed by both parties as per the requirement of legislation. Lastly, you will have those long-term leases which are required to be in writing, and if they are not, those are just but a few of the contracts that are specifically required to be in writing and therefore may be viewed as invalid if there is no signature. I hope this helps. Thank you so much.